Hi friends, today I would like to have interaction with you and discuss with you another significant topic of law regarding bail. It's regarding regular bail applications. As we know that under section 437 of CRPC, we can move a bail application before the Metropolitan Magistrate Court or Judicial Magistrate First Class, and under section 439 of CRPC, we can move the regular bail application before the Honorable Sessions Court and Honorable High Court. And we also know that in case of non-bailable offences, granting bail or granting order of the bail is discretion of the court. It is not matter of right. So therefore it depends upon the discretion of the judge. However, the discretion should not be used arbitrarily, whimsically. It should be exercised in the light of the judgments of the Supreme Court and various judgments of the Honorable High Court. Today, we are going to discuss two significant judgments related to the bail, which says that even if there is a criminal antecedents, still that will not affect the present bail applications, and even if there are criminal cases, past criminal cases filed against the accused, he is in the habit of such kind of offenses, committing of offenses, then that cannot be considered while granting the present bail, provided that from the circumstances and fact of the case, prima facie case is not made out. No strong case is made out. In such cases, the court may incline to grant the bail. So we are going to discuss about the significant two judgments of the one is honorable of delivered by the Honorable Supreme Court of India, another is delivered by Honorable High Court of Bombay Bench, Nagpur. As being advocate, we know friends that there are some factors which need to be considered by the judge while deciding the bail application. For example, whether the offense is very serious, whether investigation is completed or not, whether he will tamper the evidences or not, whether he will threaten the prosecution witnesses or not, whether he will run away from the country or not, whether the co-accused have been granted bail or not, whether charge sheet has been filed or not, likewise whether there are criminal antecedents, whether there is a history of criminal cases against such accused. These are the factors which need to be considered. Apart from this, there could be other factors also, and it is highly difficult to cover all the factors now. But these are the major factors. So one of the major factor is whether bail can be rejected on the ground that there are past criminal history and there are criminal cases are filed against the accused which are pending, and he's committing the similar kind of, he's in the habit of committing same kind of offenses. So the past criminal antecedent, how this factor affects, and what is the opinion of the two courts. One is of High Court of Bombay, another is of Supreme Court. In this judgment, the Honorable Court said that even if there are criminal cases pending against the accused, however, from the present case in hand, if from the circumstances and fact of the case, no strong case is made out, then the accused is entitled for bail. What are those judgments? I'm going to explain one by one in short fact of the case. Number one is delivered by Honorable High Court of Bombay Bench at Nagpur. The name of judgment is Pavan Nandakishore Sedani versus State of Maharashtra. Bail application number 778 of 2021. In this bail application, the fact of the case were that the accused was charged with an offense of 302, that is murder, and the entire case was based upon only circumstantial evidences. and there were no direct evidences available in the present case. Two circumstances which went against the applicant was that number one, the uh, number one, he made extrajudicial confession before one of the prosecution witnesses, and the cartouche, that is bullets, cartridge, recovery of the cartridge from the custody of the accused. So these were the only two factors. However, no one has seen while committing the offense, and the entire case was based upon the circumstantial evidences. And while arguing the bail application, the learned public prosecutor has pointed out to the court that there are criminal cases against this accused and which are pending in the respective courts. So that point was considered by the court. However, the Honorable High Court Justice Rohit Dev has pointed out specifically that from the present fact of the case and circumstances of the case, no strong case is made out, no prima facie case is made out. Therefore, even if there are pending criminal cases against the accused, still he is entitled for bail. So this was ruled, and in the instant case, the Honorable High Court has granted him bail. The court inclined to grant the bail to the accused. So what is the ruling is that even if there are criminal cases pending against the accused, but from the present case in hand, if from the circumstances of the case and fact of the case, if no prima facie case is made out, no prima facie strong case is made out, then accused is entitled for bail. Similar judgment has been delivered by the Honorable Supreme Court of India in case of Prabhakar Tiwari versus State. This was the criminal appeal specifically filed for the purpose of cancellation of the bail of two accused, as there were two separate orders came to be passed by two high courts, in which the Honorable High Court had granted bail to the accused Vikram Singh and Malkhan Singh. So two different orders were there, and the Prabhakar Tiwari challenged the two orders, and he went to the Supreme Court to cancel the bails granted earlier by the High Court. In this case, the number of the criminal appeal is 153 of 2020 and 154 of 2020. This criminal appeal arose out of these special leave petitions. In this case, the fact of the case were that the offense accused were charged with offense of 302, that is murder, and the case was also based on circumstantial evidences, and there were no direct evidences available, and the chain of the circumstances was not complete. The view taken by the Honorable Supreme Court is that the two respective order passed by the respective high courts granting bail to the two different accused, such orders these orders are correct, legal, and there is no need to interfere in the order passed by the high courts, and high court was right or correct and in passing such order. There was no defect in the order. The high court has rightly decided the bail applications and granted the bail application to the two different respective accused. Therefore, the Honorable Supreme Court in these two appeals have pointed out that even if there are criminal antecedents or criminal cases are filed against the accused, and the accused is in the habit of committing similar kind of offenses still, but from the case in hand, if the prima facie case is not made out or strong case is not made out, in such a cases the accused is entitled to get the bail. Therefore, these Two criminal appeal came to be dismissed by the Honorable Supreme Court of India, and Honorable Supreme Court pointed out that the order two order passed by the two order passed by the Honorable High Court are correct, and their bail cannot be cancelled. Therefore, the appeal filed by Prabhakar Tiwari got dismissed. The ruling made in the present case is that even if the criminal antecedents are there, criminal history is there, criminal cases are pending against the accused, however, that will not adversely affect on the present case of the bail, provided that no case is made out, no prima facie case is made out from the present fact of the case, circumstances of the case, and therefore the accused can be released on a bail. So this is the law. On the contrary, suppose if from the present fact of the case and circumstances of the case, prima facie case is made out, in such a cases, these two judgments cannot be relied upon, because in these two judgments, the Honorable Supreme Court of India and Honorable High Court of Bombay said that from the present case, if no prima facie case is made out, no strong case is made out by the prosecution, in that case, even if there are criminal antecedents, then accused is entitled for bail. However, if it is pointed out by the prosecution that the prima facie case is made out, strong case is made out in the instant case, then the advocate who filed the bail application cannot rely on these two judgments. In that case, these judgments will not help him. So this judgment will only help him that from the present case there is no prima facie case is made out from the fact of the case and circumstances of the case, even if irrespective of the fact that there are criminal cases pending against the accused. Hope that you will enjoy listening my lectures. Hope that I'm adding the knowledge. Myself, Advocate Shahid Ali Ansari. Hope that you like my lectures. Thanks for hearing to me.